Okay, now time for something else a little different. So first of all, my thanks to Farmer Jones. Farmer Jones, well now, here we are. I have something to tell you, campers. Farmer Jones posted some comments about the settlement agreement, the statement of guilt, and with Imran Awan. And he also posted a link to it, which I'm also going to do. And it's a 12-page agreement. And there have been people who've said, obviously this is letting people off, this is playing games, this is more of the same. I'm going to tell you I don't think that's quite true, and I'm going to tell you why. Having read through it, I appreciate that this is a nicely leveraged agreement. So basically what they did, and you may well have heard this somewhere else, they got Imran Awan to agree that he had violated making a false statement on a loan or credit application. Now that sounds absolutely insane, and frankly it is, but it's the way the feds do stuff, right? So if you didn't clip your toenails properly and there's a federal statute on it, they can use that. And when they file charging papers, especially if they have somebody they want to leverage, they put all the nasty stuff in and then they work out from there. And they're attempting, I think it's pretty obvious in this, they're attempting to get Imran Awan to cooperate, and I'll show you why. So, first of all, he made some kind of false statement, and of course the bankers are better protected than anybody, and that should tell you more. How well are they protected? Well, here's what happens or could happen for making a false statement to a bank in the process of a loan application. That sounds like 6 months offense, sounds like a misdemeanor, sounds like a slap in the hand or maybe a revocation of your rights. No, that's not the way it works. Your client understands that a violation of 18 U.S.C. 1041 excuse me, Section 1041 requires allows for a maximum sentence of 30 years and a fine of $1 million or twice the pecuniary gain or loss that you had from making the loan. So for most of us, if you make a false statement on a loan application, and that gets swept up into the federal investigation that they are doing of you, they have the right to charge you with this violation and to go after you in the deepest sort of way. And it can be very expensive, and that doesn't count the $100,000 you're going to spend defending yourself with the attorney's fees and the rest of that. It doesn't offset or include the bond that you have to file and 100 other things, them cuffing you and fingerprinting you and holding you for a couple of days. Preferably they arrest you on Friday afternoon on a long weekend, so it's Tuesday or Wednesday before you can even get a bond hearing. It's all beautiful stuff. So they also, there are all these tangential things which say you got to pay $100 for your criminal conviction, and you also have to pay additional charges, or you may be charged with it. So if you have money, you can be charged for your incarceration for the time that you're spending in there. Now, there's an interesting little piece that goes with this, and this is fairly typical, and I'm going to tell you it may well be on the Flynn plea agreement as well. There's a statement that the feds will not charge Hina Alvi, which I'm going to take to mean that this is probably Imran Awan's girlfriend. I'm guessing he's heterosexual, can I say it? And that they will not file charges against her as well. They also estimate the offense level, and this is supposed to be a 7th level offense. I'm not a federal attorney. I don't practice in federal law, didn't. And so I can't tell you exactly how that fits into the sentencing guidelines, but they agreed to do a 2-level reduction provided that he's a good boy. They agreed to adjust it provided that he cooperates and that he doesn't do anything else untoward. They talk about the guideline range, and the guideline range is for a level 5 offense. It's estimated the applicable range is from $500 to $9,500 penalty, which is not much, and from 0 to 6 months at level 5 for the estimated guidelines range. So he could walk with nothing, and that's what they're offering him. So why did they do that? Well, first of all, you can say that they have acknowledged that he did nothing with the House of Representatives. They have said in this statement relative to sentencing that even though they are dismissing other charges, that the government is actually saying, we spent time, we interviewed 40 witnesses, we looked at all the documents, we looked at servers and data and electronic communications, etc., and we found nothing to say that you took or interfered with or manipulated computers, hard drives, electronic devices, etc. in the House of Representatives. I think that's a fairly big comment. Now, does that mean that he didn't do other things that are applicable? And I think you'll find that he did. There are the usual kinds of things where both the government and the defendant have the right to talk to the judge at the time of sentencing. There is no necessary hurry in sentencing, and you saw that, and you are seeing that with Flynn. That they keep putting off, and I think they've put off 3 or 4 times now his sentencing. They're going to do this with Imran Awan as well. Why do I say that? Well, because they're going to use him, and the best leverage they have is to keep this hanging over his head all the time that they are using him. So you cooperate, you get charged with one little piddly deal. If you don't cooperate, you and your girlfriend are both going to be under the hammer, and all bets are off. And we're going to go after you for the biggest things we can find. So that's the leverage. And, you know, it may also be that they had something else on Flynn, but it may be that that was all they could find on Flynn, and that there was nothing else there except for lying to the federal officers when he was interviewed. So my answer to you is, if a guy says, I'm a Fed and here's your card, you say, well, thanks, I'll see my attorney. I'm not telling you anything except my name, rank, and serial number, period. Nothing, absolutely nothing. So, there's the standard comment, and I'm going to give you some of the standard stuff because this helps give you the complex, around a whole sentencing agreement or a plea agreement. And some of those are that the court is not bound by it. So the court can say, hold it here, I don't agree with that. And both of the parties have left themselves open to provide information both to the reviewing officer that's going to submit a sentencing report to the court, as well as to the court themselves. So they're both going to give their best information. And if in fact Imran Awan is fully cooperative, the defense attorney is going to say, look, we cooperated in all these respects, and probably the government is going to say, yeah, absolutely, we agree that he did, and therefore we recommend or ask you, Mr. Judge, to consider leniency in this case because we got everything out of him we could. So one of the other things that are obvious, and this is true in any kind of plea agreement, is that the defendant waives a bunch of stuff, and some of you may know all of this, but I'm going to give it to you as well, and then I'm going to go back and talk a little bit about what other kinds, how the leverage works into it. So one of the first things they did is say that this applies to the venue, and they used the Washington, D.C. as the venue. So he can't come in and say, no, I want this to be another venue. Secondly, he gives up all of his trial rights. So he waives the right to a trial. He waives the right to a trial by jury. He waives the right to confront his accusers. He waives the right to present his own witnesses, to present his own trial. He waives the right to any discussion about instructions to a jury or instructions to the finder of fact, which could in fact be the judge if he waives the right to a jury. He gives up the right to alibi. He gives up the presumption of innocence, and they severely limited his right to appeal. And also, as I kind of mentioned, if the judge gives a sentence that's out of the guidelines, he agrees that he has waived that. He is acknowledging and knows that the judge could say, no, well, you guys have this agreement and everything, but the federal government did not give you an out if I give you 10 years in prison instead of 2 months. You still are subject to the guideline, are subject to your agreement. And should he revoke any of his agreement, should he revoke, that is, should he violate any of these terms or fail to cooperate, what the feds say is all bets are off. We have the right, if you don't cooperate, to treat this as a breach of agreement, and you and your girlfriend will both be fully charged. That is a big deal. And now what they did is they sent this letter, and you have to appreciate that attorneys were discussing and playing the whole time. This is all in the background. And so finally the prosecution says, well, look, we have all of your information, you have all of ours. You've told us that you will likely take X, Y, and Z. We're going to write you up a letter that becomes an agreement if you sign it, and that's what they did. So the letter was signed and sent on, I think, the 3rd of July, and Imran Awan and his attorney, Christopher Gowan, both signed it that same day. So obviously there was some cooperation in that. So let me finally tell you the other thing that is applicable to this and is important. Number one, pieces of it, right? Anything he does now is excluded, so they can charge him with any new offenses. And this agreement is limited to the District of Columbia. And I don't know whether anybody else is going to point this out, but it only applies to offenses that might have been committed in the District of Columbia. Not only that, it only applies to non-violent offenses that might have been have occurred inside of the District of Columbia. So if he committed violent acts of any kind within the District of Columbia, those are not waived and released by this agreement. So he could still be charged with any violent crimes within the District of Columbia. What is more, and this may serve as huge leverage that we don't even know about, that's not implicated in this agreement, is that anything he did out of the District of Columbia is fair game yet. So if he was in Los Angeles and committed crimes, or in Chicago or St. Louis or anywhere else, or conducted offenses in cooperation with other people that might have been outside of Washington, D.C., that would constitute crimes conducted in other venues, in other jurisdictions, then he could be charged with those as well, even though he has an agreement here. And so they may have set, that is, the feds may have set aside whatever else they know about him that could have occurred outside the District of Columbia. So this is a fairly narrow plea agreement, and it is only applicable to nonviolent stuff within the District of Columbia prior to the execution of this agreement. And it leaves the feds open with lots of leverage, and you can bet, as they have done with Flynn, you can bet they're not going to sentence him until they're satisfied he has told them what he is supposed to tell them about other offenses that might have gone on. So who are they after? Are they after people within the Democratic Central Committee? Are they after Debbie Wasserman Schultz? Are they after the Clintons? Are they after others? Are they after low-level perpetrators that might have been doing dirty works within the Democratic Party, or 100 other things? You know, I don't know. And frankly, I don't know what the internal workings of Imran Awan are, or what he has been investigated for, other than what is covered here and what is general information. So but this gives you a fairly good sense, I think, I hope, of how it is that this sentencing agreement came about, plea agreement and sentencing, pre-sentencing agreement, and how it might play out, and what are the exclusions within it for both of the parties. So Imran Awan has a very limited right to object. I think ineffective counsel or something like that he could still appeal from if it could be shown that his attorney was an idiot, which happens, right? But it isn't going to happen here. And so anyway, that's the net of it. Again, thanks to Farmer Jones, because he's the guy that helped me locate this in the first place. And I will attach a link to it, and so you can take a look at it and go through it and see if you agree with my assessment of the plea agreement and how it's going to play out. Thanks so much.